Your Honors, if it pleases the court, Miss Amanda Benjamin will give the closing statement on our behalf.
Very well.
Your Honors, allow me to draw an analogy that reflects our shared realities in the Caribbean. A company is much like a fishing boat setting out to sea, with every crew member having a specific role. And when one fails to pull their weight, the net comes back lighter, the catch smaller, and the entire team is made to feel that strain. The company, like a responsible captain, provided every tool. The company provided every opportunity. The company even provided training to help the worker improve. Yet, despite all efforts, the workers' action or lack thereof continue to harm the business and the livelihood it supports. This case is not about quick dismissals. It is not about unfair treatment. It is about safeguarding a vessel that supports many, while ensuring the principles of fairness and natural justice were upheld every step of the way. The evidence demonstrates that the company acted reasonably, the company acted professionally, and the company showed genuine care for both the worker and the organization as a whole. The union may argue that the termination was unfair or lacked due process. However, the facts presented in this matter clearly refute this claim. The worker was fully aware of the performance concerns, as they were communicated through regular assessments, notices, and direct supervision. Furthermore, the company went beyond its obligation by providing internal and external training. The company provided performance improvement plans and coaching. And I know that members of the union made mention a while ago that, you know what, Ms. Small could have done more. How much more could she have done? She was consistently putting things in place to help Mr. Small improve, and she wasn't getting anything back in return. So despite all these interventions by Ms. Small, all the interventions by the company, the worker failed to meet the required performance standards. The decision to terminate the worker's employment was not hasty or ill-considered, but rather it was the last resort after exhausting all reasonable measures to support his improvement. It wasn't an easy decision, but as much as possible, we too had to ensure that the business was able to carry on. Should we have retained Mr. Prince under these circumstances, we would have jeopardized the sustainability of the business. We would have jeopardized team morale. We would have jeopardized customer satisfaction. We would have jeopardized the reputation of the business. Your Honor, we respectfully urge this honorable court to find that the company acted with fairness, transparency, and in line with industrial relations best practices. The termination was both procedurally and substantively fair, as evidenced by the worker's failure to fulfill his obligations, despite the company's extensive support. The company therefore requests that this honorable court dismiss the trade dispute and affirm that the termination was lawful, the termination was justified, and the terminations were aligned with the principles of natural justice. Your Honors, I thank you.
You take your seat. Would you say this is a case that attracted progressive discipline? One. If so, did the court treat with it along that line?
I would say yes, that it attracted progressive discipline because when Ms. Small met with Mr. Prince in the quarterly reports, he was given an opportunity to comment based on his performance. And it will show, even when we go back to the annual reports, the annual evaluations, every evaluation it was stated, Mr. Prince, I needed to improve on attendance, I needed to improve on punctuality. And it wasn't addressed. So, Ms. Small, if you ask, the company was very lenient with Mr. Prince. And it all comes from a place of genuine concern and care for the worker. But as illustrated earlier, there's so much you can do. And we also took into consideration, rather, based on the findings of this court. Now, if it's a case where Mr. Small, sorry, my bad, Mr. Prince, based on what was brought forward to us, he forgets a lot. If you look at the nature of the case, Mr. Prince, right? He did not remember to submit the sick leave. Mr. Prince believes he told the company about the issue with the phone. Mr. Prince alleges to forget, but never once did he say, you know what? I tend to forget, maybe I should walk around with a little notebook and a pen so I can help myself to remember. Mr. Prince did not take enough responsibility and accountability in the situation.
In this case, were any charges laid?
No, sorry. No charges were laid.
Was there an investigation?
No.
Would you say-
Investigation.
So is it true to say it is a summary dismissal?
Yes, it is.
And with a summary dismissal, would you agree, would you not, that the threshold that the company has to meet is much higher? It isn't to say that in every instance they must have a tribunal, charges and so forth. But in the absence of that, would you not agree that the threshold is much harder for the company to satisfy that they would have made the result would have been the same had they had a tribunal? What say you on that?
Honorable Judge? Yes. Mr. Prince was, when you look at the gravity of the performance issues, we believe that we could not take that chance to continue on that route. Because, as Ms. Small said in her statement, today is one story, tomorrow is another story. So now we would have, had a situation where we lost all these funds, And in addition to that, we lost 15 customers. We lost 15 customers. That amount of money that we would have lost through the business wasn't something that we could continue tomorrow or the following day. So we believe, Your Honors, that the best decision was taken.
And I would call you counsel. I'll refer to you as counsel. I can't remember your name right now. Counsel, as this court has pronounced on many occasions, when parties arrive at the court, here is not the place where you have a chance to do over your hearings and give workers opportunities that they should have been given at that stage of the procedure. Having said that, this court is not to determine whether the worker is innocent or guilty of whatever charges were preferred on him. But the court is to look at the process and ensure that it is fair and just and is in keeping with good practices, the principles and practices of good industrial relations. And as my chair has pronounced in many of his judgments, that even when Cain killed Abel, God knew, but he still reached out and asked Cain, what have you done? And that was done to give him the opportunity to be heard. So, even though the company would have looked at and afforded the appraisals and afforded the coaching, the manner in which the worker, the company took the decision to sever its relationship with the worker, the court would look at it and determine whether or not it was in keeping with good industrial relations practices.
Thank you, Your Honor.
Thank you very much.